Morning, Your Honors.
Morning. Is Mr. Nation with us?
I am, Judge. Good
All
morning.
right, sir. Good morning. Okay. Help me pronounce your last name, appellant's counsel.
It's Labby, Your Honor.
Labby. All right, sir. Are you ready to proceed? Would you like some rebuttal time?
Yes, Your Honor. 3 minutes for rebuttal, please.
Yes, sir. You got it. Go ahead.
Thank you, Your Honors. So there's a lot of issues at this points of error in this one, so I will jump right into it. And I'm a naturally fast talker, so I apologize in advance. I'll try to go at a reasonable speed, though. The first issue I want to get to is the issue of the trial court allowing the plaintiff to introduce evidence of work and repairs that they contend would have been necessary to undamaged portions of the property. So the parties stipulated prior to trial that they were limited to actual cash value. The dispute that arose was, well, what does actual cash value mean, right? So what the Vasquez versus Citizens case says out of the third DCA is that initial payment obligation of an insurer is limited to the actual cash value of the property that was actually damaged by the loss. And that's consistent with the terms of the policy, which say that the insurer is going
to. But in Vasquez, Citizens paid the actual cash value. Here, your client denied coverage, correct?
Correct, Your Honor. It wasn't.
But it seems like to me the third DCA and Citizens TO made that a distinction.
Yes, sir.
Everything's off the table now.
Yes, Your Honor. So a couple of points of distinction. So that the TO case would really be of, are they limited to actual cash value or can they get replacement cost? But in this case, the parties stipulated that they were limited to actual cash value. It's right in the trial transcript, because there was a motion on it, and he said, Mr. Nation said, if they would have had their hearing, but we agreed that we wouldn't ask for replacement cost value. We are asking for actual cash value without matching, with the opportunity to ask for further amounts as the work is performed pursuant to the loss provision. So that takes TO out of the equation, in my opinion, because they are agreeing that they are limited to actual cash value.
Aren't they asking for actual cash value for trenching to get to the pipes?
Yes, Your Honor, which would be, so again, the issue is what constitutes actual cash value. So can you include work to undamaged portions of the property as part of actual cash value? And that's why Vasquez is important, because it says no, that the actual cash value is limited to the property that was actually damaged, because the policy is going to be limited to, direct physical loss. And the policy actually says that we'll initially pay the actual cash value of the insured loss. And the insured loss is the direct physical loss. So in this case, they're saying, okay, essentially there was some water damage to the fill, to the dirt beneath the house. That is the insured loss in this case. That's the physically damaged property. The other work to undamaged portions of the property, that constitutes amounts necessary to perform such repairs. That's not part of the actual cash value of the insured loss. So it was error to allow the plaintiff to present evidence, to present argument, to present that estimate that included work to all these undamaged portions. Now, it seemed like the plaintiff's argument below, they focused on, well, Vasquez just said, you can't get matching as part of actual cash value. And that's true. It was matching in that case, but it's not limited to matching. Again, you can only get the actual cash value of the property that was physically damaged, of the direct physical loss. So whether it's matching, whether it's ordinance and law, or whether in this case, it's any remaining amounts necessary to perform such repairs, that's all part of replacement costs. That's not properly part of actual cash value. So it was error for the court to allow that to be considered with their evidence. And again, it kind of goes hand in hand.
Mr. Labby, may I enter? Because
yes, Your Honor.
The court in the final judgment did acknowledge, it says, in this trial, the party stipulated that plaintiff is only seeking actual cash value. And so the court did recognize that as well. And so you're taking issue with the fact that this may be a problem here?
Well, Your Honor, we take issue with the fact that although there was a stipulation that they're limited to actual cash value, she allowed plaintiff to claim amounts that are not part of actual cash value. So essentially what happened was we stipulated, and they entered into evidence an estimate that was for all the repair work that could be necessary to trench, to access the pipes, to access the fill that they're saying was damaged. And then they said, but you know, we take some depreciation off of that, so that's the actual cash value. But that's not how it works, because again, the actual cash value is limited to the property that was actually damaged.
What property are you indicating that was damaged because of the trenching, but wasn't damaged because of the pipe burst?
Nothing in their estimate, Your Honor, has to
No,
do.
no, what are you claiming that you're having to pay for that you're not required to pay for?
So, Your
I
Honor,
mean, trenching, when you're trenching, you're gonna tear up something that may have not been damaged.
correct,
But
Your
your
Honor.
policy pays for it.
Correct, Your Honor. Once that work is performed, absolutely. But that work has not been, none of that work in that estimate had been performed. None of that. So that was all things they're
Then
saying.
why'd you stipulate the actual cash value? Because you're sitting here arguing the actual cash value refers to what's already been done, but you stipulated. So what's the point?
No, no, no. We stipulated that all they can recover under the policy is actual cash value. What the actual cash value is limited to the value of the property that was actually damaged by the loss, which in this case, they claimed some structural fill was damaged. And I think a CMU block, they said that the water kind of seeped back up through that. That is what the actual cash value of the loss should have been. What they did was they said, okay, we're going to introduce an estimate for all the work to this non-damaged portions of the property, completely undamaged portions of the property that we say are going to be necessary to perform these repairs for the direct physical loss. And they claimed that that was part of the actual cash value. And that is where the error occurred. And the trial court erred in allowing the introduction of that evidence, erred in failing to give the instruction as to what actual cash value is. So again, the stipulation was all they can get under the policy is actual cash value. The dispute that arose, and what we're asking the court to rule on, is what is actual cash value? As part of actual cash value, can you claim repair work to property that was not damaged by the loss? And again, the policy is really crystal clear on this, where it says, we will initially pay actual cash value of the insured loss. So that is the actual cash value of the direct physical loss. We will then pay any remaining amounts necessary to perform such repairs as work is performed and expenses are incurred. So everything in their estimate, the trenching, everything that hadn't been done, those would be amounts necessary to perform the repairs, the actual cash value of the insured loss. None of that.
Was ACF defined in the jury instruction?
No, Your Honor, we asked for a definition and the judge declined to give it.
Then how was the jury instructed on finding actual cash value?
They were not, Your Honor. There was no instruction on it. The judge said something to the effect of, you know, this isn't a case about actual cash value. This is a case about trenching. But the judge declined in two different places. Yeah, I have the quote here. She said, when she declined to give the instruction, she said, this is a tear-up case. It's not a case of what's the actual cash value. This, which she's referring to our ACV instruction, relates to the repair and damage to the property. And here we're just talking tear out. But again, what we're talking is damages. What damages are they entitled to under the policy? And everybody stipulated that they were limited to actual cash value. So again, based on Vasquez, based on the language of the policy, it was error to allow consideration of those non-damaged portions. There's a case out of the Southern District, Escudero versus certain underwriters at Lloyd's, a 2022 case, where it kind of dealt with this similar issue where essentially the plaintiff said, well, I have this RCV estimate that has all the work that could need to be done, including undamaged portions of the property, but we can get to ACV from that by just appreciating it. And the court said, no, that's not how it works, because you didn't limit the RCV estimates to the damaged property, but rather the property as a whole, including the undamaged portions. And the court went on to say that the cost to repair or replace non-damaged property are not available under the contract until after repairs are made. And in any case, they have no bearing on any determination of actual cash value. Work that might be needed to non-damaged portions of the property, it has no bearing on what the actual cash value of the insured loss is, right? Because all that matters is what property suffered a direct physical damage. What is the actual cash value of the damage to that property? And that is what is initially due. anything.
Mr. Labby, can I enter, because I was trying to pull this, that's why, I know you've moved on to a thing, but when you mentioned that you've only stipulated to actual cash value, I was able to pull up the quote. Basically, the agreement, plaintiff will only ask for actual cash value of water damage and tear out without matching. And so, and then you went on to say the plaintiff does not waive the right to file a supplemental claim for withheld depreciation, matching to be paid as the work. So Universal stipulated that. And so at trial, this is what I'm trying to find out. You're taking the position you've only stipulated actual cash value, but it looks to me that also the tear out was part of that. Am I reading it incorrectly?
Your Honor, I would say that that was merely defining what the loss of the claim was, but it's still limited to the actual cash value of what that tear out would be, which in this case is there is none because the work was not performed. So there's no, and they didn't establish any tear out that was necessary because of the direct physical loss in this case.
Isn't that something the jury was able to, I mean, this was a evidentiary matter, went in front of the jury heard what was damaged, what needs to be done, and so awarded an amount that would be appropriate, and the amount to which they conclude, when I say appropriate, that's what they concluded, is the amount that, yes, actual cash value, but also what will take to basically fix it. And so it's just, I just want to make sure that I'm not misunderstanding your argument on appeal, that you've only agreed to actual cash value and to exclude the tear out.
Well, Your Honor, again, so we stipulated that it was actually the plaintiff stipulated that they would be limited to the actual cash value of the loss.
And I think in this one I misspoke, and you all, both of you guys, even you all agreed, as I understand it in the record.
Correct, Your Honor. So I believe it was in response to one of our motions in limine that they stipulated we're only going to seek actual cash value of the loss. So whether it's whether we include the term tear out in that, it doesn't change the analysis of what actual cash value is. And the jury was not able to make a determination as to what the actual cash value of the insured loss was, because they were presented with an estimate that included work to undamaged portions of the property, and the trial court declined to give an instruction as to what actual cash value means, explicitly saying she didn't think that this was an actual cash value case, it's just about tear out. I think sometimes it kind of gets lost that, you know, this is a claim, this is a lawsuit for breach of contract. So the only, regardless of what it's not, they can sue us and say, what does it take to put the house back together? It's what is due under the policy, right? And they're agreeing they're limited to actual cash value under the policy. And again, there's this disagreement as to, can they include all these areas that were not damaged by the loss for work that has not been performed as part of actual cash value. And our position is that they can't. And we believe the trial court erred in not only allowing the submission of that evidence, but in failing to instruct the jury as to what actual cash value is, which really prevented them from even considering the issue, basically just having to take the plaintiff's position that actual cash value is everything that it's going to cost to make the repairs minus some depreciation, which is not how the policy is written. It's not how the law defines actual cash value.
And do we know in this case of the jury, how do we know based on this record that the jury awarded more than actual cash value?
Because they awarded damages based on plaintiff's estimate, Your Honor. And plaintiff's estimate included almost nothing in that estimate has anything to do with the actual direct physical loss in this case. It's all has to do with trenching that they're saying will be necessary to access the plumbing system to make the repairs. And that kind of dovetails into my next argument, which, unless Your Honor, Judge Kazim, if you had other questions, I'm happy. Okay.
Thank you.
Which is that the trial court erred in both denying our motion for directed verdict and in instructing the jury that the policy covers tear out to access for replacement of the entire system. So the policy in this case is explicit as to what happens in these situations. So essentially, just briefly, what happened is, you know, they claimed that there was a leak and some backfill was damaged, but then their expert said, but we can't repair the plumbing system. We have to replace the entire thing, which means we have to have tear out to access the entire thing to replace it. The policy specifically limits the tear out coverage. It says the cost we will pay for the tear out and repair above is only that cost necessary to access and repair only that portion or part of the system that caused the covered loss, whether the system or any part or portion of the system is repairable or not. So it does not matter as far as tear out coverage. It does not matter if the system can be repaired. And then just to kind of take any question off the table, the next paragraph says, in the event that additional tear out and repair are required beyond the coverage provided for access and repair in the provision immediately above, we will still pay only for our portion of the access and repair costs required to repair only that portion or only that part of the system that caused the covered loss. So the policy provides very limited coverage for tear out. It says we are only going to pay for the tear out necessary to access that part of the system that caused the covered loss, that part of the system that caused the direct physical loss. We move for directed verdict on this issue because at no point did the plaintiff's expert testify as to what part of the system caused the covered loss. At no point did they present any evidence as to which part of their estimate, because again, it includes tear out to replace the entire system. At no point did they present any evidence as to which part of that estimate was for tear out to access the portion of the system that caused the covered loss.
You didn't, your client didn't call a plumbing expert at all. It was only the plaintiff's expert. You're sitting here arguing what appears to be speculation, but the only expert testimony in the record is from the plaintiff's plumber, who said this was wear and tear, deterioration, corrosion, which is in your policy. And your policy says we cover that loss, including the cost of tearing out and repairing only the part of the building necessary to access and repair the system. That's what he testified to.
Well,
what other evidence contradicts that?
Well, Your Honor, it's their own evidence. It's their burden to prove their damages, right? So they needed to establish what part of the system caused the covered loss. So they could, that's the only way to establish, if they want tear out coverage under the policy, it's limited to the tear out necessary to access only that part of the system that caused the covered loss. So it was incumbent upon them to have their expert say, this is where the leak occurred in the beneath the guest bathroom. So we need to tear out the floor in the guest bathroom to access it. And they did not do that. So they failed to prove their case. We don't need to put on an expert to it's their burden of proof, I should say. Their expert didn't say that. Their expert said, there was some backfill that entered into the plumbing system and it's not repairable. And so this becomes important with how the jury was instructed. It's not repairable. The only repair is to replace the entire system. So not only did the trial court deny our motion for directed verdict, she actually instructed the jury that the policy covers tear out to access and replace the entire system if that's the only proper repair. That is the exact opposite of what the policy says. She completely read out those two provisions of the policy. They are meant to, you couldn't sit in a classroom and come up with a better example of what those policy provisions apply to than a situation where you have a limited loss to structural fill. You have an expert saying, we can't make the repair. We have to replace the entire system. That's exactly what those provisions do. What they do is they actually make the proper method of repair irrelevant to the consideration of what tear out is covered, because they say that's all we're going to pay regardless of whether or not it's repairable and regardless of whether or not additional tear out and repair is needed. We still only pay for our portion. So it's a limited portion, and the judge erred in instructing the jury that the policy covers tear out to replace the entire system, despite the fact that that provision says the exact opposite. It's the polar opposite of what the judge instructed is what that policy provides coverage for. It says if you need to replace the entire system, that doesn't matter. We only cover the tear out necessary to access the part that caused the covered loss. There was no testimony in this case as to what part of the system caused the covered loss. And certainly it was error to instruct the jury that the policy covers something which the unambiguous and clear language say that is not covered. I mean, it's if the plaintiff's argument is correct and the judge properly instructed the jury, what do those policy provisions, what do they mean? What do they do? They would have absolutely no effect. They would be superfluous. I mean, just basic concepts of contract interpretation. We have clear and unambiguous language. We have an interpretation that would render those provisions absolutely meaningless because she's instructing the jury that the policy is going to cover tear out to replace the entire system only because their experts said you can't repair a portion of it, when it literally says, doesn't matter if that part or portion is repairable or not, doesn't matter if additional tear out is necessary or not. We only cover the access for that part that caused the covered loss.
And you don't think
Well,
it's
but it appears
to
that,
follow up with what Judge Sleet said, for you to have your own expert to say, we disagree with that expert. You don't need to replace the whole thing. This is where, in our opinion, the leak occurred. You need to limit it to this amount. You don't have that here. So the only thing that you have is the insurance expert setting forth his opinion that does include the tear out. So how do you reconcile that?
Sure, Your Honor. And it goes back to my point that the proper method of repair of the system is irrelevant to the tear out coverage. So it wouldn't matter. We could have had our expert go up there and say, yeah, the only way to fix this is going to be to replace the entire plumbing system. It does not change the fact that the policy says in the event that additional tear out and repair are required beyond the coverage provided, we still only pay for our portion, which is to access only that part or portion of the system that caused the covered loss. So it is.
well, but your trial lawyer below conceded that if it's structural fill, it's part of the house, which is covered. And that's what the trial court found. And the only evidence in the record is the plumber saying this is structural fill. I mean, this is part of the house. This isn't just dirt like you're talking about, backfill. Part of the house was deteriorating because of this sewage and contaminated water that your lawyer below was trying to say, oh, this is a pre-existing tile problem. Pure speculation. I mean, you didn't bother to call an expert. You didn't call him a plumber. Yet you're saying that this is just finite damage and we're just going to cut out a little 4x2 area just to fix this. When the testimony was replete that this is sewage, and every time that leaked, more damage happened.
So, Your Honor, just a couple of points. Just to clarify, I don't believe that trial counsel conceded that. I believe that was an area of dispute that a directed verdict was actually granted on.
Record 448. I concede the fact, obviously, if you say it's part of the drain system and it's not part of the land, then they've got testimony that's their damage here, and that would be a directed verdict. That's your lawyer.
Yes, Your Honor. So I think that's. I think that he was saying that if that is Your Honor's holding, that it would be part of it. But I think regardless, the distinction that I'm trying to make, and it's not. Listen, it's what the policy is. What the policy is. The policy covers what the policy covers. Right? Their expert did not say that every part. Their expert did not say that the entire plumbing system has to be replaced because it is causing this damage. Their experts said that the plumbing system is so worn, so deteriorated that a repair to the part that was causing the damage was not possible. So you have to replace the entire system. At no point did they take the position, not even on appeal in their brief, did they say, no, it was the entire plumbing system had to be replaced because it was all causing damage. It was all leaking. That's not their position at all. It is.
Well, on the same page, 448, the court said, I did make some notes on that during the testimony of Dorimco, which is the plaintiff insured's plumbing expert, said the only fix is to trench out, tear out, and repair. And Dennis James said the structural fill is damaged and the sewer system is damaged. New damage every time the water is used. There's no objection from your trial counsel below whatsoever. No motion, no nothing.
Your Honor, I mean, that's what we did. We did move for a directed verdict on, again, we moved for directed verdict on the fact that they had not established what part or portion of the system was causing the loss. What their experts said, again, and let me see if I can just find, I can send you point you in the right direction. I believe it's 354 of the transcript is when their expert was testifying. So we see evidence of sand and backfill, toilet paper. There have been no repairs at all to the drain line, correct? And all right, and I believe you testified that the drain line was so rusted and corroded from wear and tear that it is not repairable, correct? Correct. So you're saying the only alternative is to replace the entire system. That's correct. What other repair options are listed? We have what we call a trench list where we insert a liner. So it goes on and on. But the point is that the only evidence or testimony presented in the trial court that the entire system needed to be replaced was not because the entire system was causing direct physical damage. The entire system, not every part or portion of the plumbing system is leaking into that backfill. He's saying it's so old, it's so deteriorated, it's so rusted, we cannot repair it. We have to replace the entire thing. That's all well and good. That does not need to be disputed. The fact is that regardless of that, the tear out coverage provided by the policy is still limited to only the portion of the access and repair to repair only that portion that caused the covered loss. And
All right,
here,
you're at 18 minutes. You can use your time as you wish.
Your Honors, just very briefly, so I can address it more in rebuttal, but the post-loss duties, so essentially we have a situation where we move for summary judgment on their failure to comply with post-loss duties. Their argument was more or less, well, we gave you all this stuff after we filed suit, and then we made this kind of quasi-settlement offer to stay the case for a period of time, and if you pay our estimate, then we can be done. And the court denied our motion for summary judgment, but she went a step further, and she actually found as a matter of law that plaintiffs' post-suit attempts to comply with the policy conditions cured any failure to comply, and we were not able to present that argument to the jury. That was the basis for the denial. Obviously, I feel that summary judgment was warranted based on the briefing, but at the very least, that has to be a factual issue for the jury for us to be able to say, we asked 6 times pre-suit for this stuff. They never gave it to us. 10 months after suit was filed, we got some documents. A year and a half, they finally offered to sit for a recorded statement. Is that substantial compliance with the terms and conditions of the policy? Does it violate the suit against us provision? We weren't even able to present that issue to the jury. On a claim that was denied for failure to comply with post-loss duties, we were not able to present any of that argument to the jury. And I'll reserve the limited time I have left for rebuttal, Your Honors. Thank you.
For 1 minute. Okay. Good morning, Mr. Nation.
Good morning, everybody. Mark Nation on behalf of Appellee Mr. Walsh. I'll address the 3 issues that he addressed and obviously available for any questions. The first one is the ACV argument. If you look at their motion in limine, and that's at 302 of the record, what they filed and said in their motion in limine was that they wanted to prevent us from presenting any evidence regarding matching or any damages. But what they agreed we could present is our damages need to be limited to accessing the drain line in only the damaged area. That's what they said in their motion, that we couldn't ask for matching, but we could ask for access of the drain line. So that eliminates their entire argument. We got that and then reached an agreement. Had we not reached an agreement, I would have said, TIO controls, this is a denial. We're right under TIO and we're allowed to get replacement cost value with matching. But as an accommodation, we will short circuit it. I will agree that my client will only ask for actual cash value of the water damage and the tear out. And that was in response to, to their motion. Had they not agreed to that, I would have gone and argued TIO. I suspect we'd have been successful on that because it's right on point, and Vasquez has nothing to do with our case. Vasquez, there was no denial. There was a payment. They were substantially overpaid, and then they wanted $70,000 for matching. That's what Vasquez is limited to. And both those cases actually came out of the third, as court noted, on the same day when one of the judges was on both panels. And so that agreement was made. Had it not been made, I would have been able to pursue replacement costs, and I would have pursued it. And the judgment sets all of that forth. We also included our right to file a supplemental claim for matching and recoverable depreciation as the work is performed, pursuant to the loss settlement provision. That's an accommodation. We avoid a hearing. We make the trials shorter, and my client can start the repairs. What they're arguing, though, let's say this motion, we hadn't agreed to it. A huge difference between what we have in this case and Vasquez is, in this case, the policy covers and defines the loss as water damage, including the cost of tearing out and replacing parts of the home necessary to access the pipes. It's a huge difference. In other words, we'll pay for the water damage and the thing that caused it. It makes no sense that they would be required to pay under the policy. We'll pay for the water damage, but we'll only pay this huge bill for the thing that caused it after you do the work. That doesn't make a bit of sense. And so that's a difference. It defines the loss. Their ACV or their loss settlement provision says we will pay at least the actual cash value of the loss with any remaining amounts to be paid later. Well, what's the loss? The loss here is the water damage in the tear out. But I don't know if I need to belabor that point. Let me see if there was any other note on that. Oh, and then the estimate put in was an actual cash value estimate. It was actual cash value of the trenching, and that exact amount is what was awarded by the jury. Now, they got to argue whatever they wanted to argue as to whether or not the amount of the tear out that we were requesting was appropriate, whether it should have been confined to a small space or a larger one. Fair game. And the burden of proof was on me on that. That's the final question on the verdict form. I had to prove what the right amount is for that tear out. The jury did what they did. Let's see. Oh, and the court asked if there was a definition of ACV. There wasn't, and the ACV is defined by the Supreme Court in a case called Trinidad, and the only definition we have from the Supreme Court is actual cash value is the replacement cost minus depreciation. And we know from the second DCA in a case called Goff that it doesn't mean only damage, because the Goff case out of the second DCA said you can get the ACV of overhead and profit from a contractor for work that's not been done. And the work doesn't have to be done. I don't know if I want to or need to belabor that. If there are questions, I'll deal with that. The second issue was the, quote, replacement of the entire system. We never asked for the replacement of any of the system. We made it clear from the opening through our witnesses through closing, there was nothing in our estimate for the system itself. The system itself is not covered. What we said in painstaking detail through our expert witness in this case, as I went through the videos, is there a breach here in the lines? Yes. Is there structural fill being damaged in real time in this video shot right here? Yes. Can we see an opening? And those openings were throughout the entire system, damaging a structural component of the home, the fill. The only way to access that fill, the damaged fill, forget about the coverage for tear out to access the system. We had damaged fill that had to be accessed. And I made it clear with our plumber and our GC, the only way to repair the fill is to do that trench. As to the limitations that are in Universal's policy as to how much of the system is, or how much of trenching is available, that's right in the jury instructions. It specifically says it has those limitations. I think on page 2 maybe of the jury instructions, those were argued to the jury. The counsel at trial did argue or try to argue that if it's the entire system, it's excluded because that's not a repair. But and so the court addressed that issue and said, well, if that is the only repair available pursuant to the terms of the policy, then that would be covered. That certainly clarifies that. Let me see if there was anything else on that. Oh, and I can't say for certain right now, but I'm pretty sure I would have made the point. A spot repair, if they'd have tried to just do spot repairs throughout the entire system, would be a whole lot more expensive than what we were submitting to this jury. And I do know throughout our testimony of our plumber, I made it perfectly clear. The loss was being caused by the entire system. There wasn't a single point that caused the loss. And I probably said that multiple times. They said the judge erred in instructing the jury concerning the appropriate repair. Again, that was right after the policy language that has the limitation on it, and it clarified, truthfully and accurately clarified the position or how the policy should be interpreted. But I don't believe they appealed that issue, and it certainly wasn't preserved. That jury instruction, unless I missed it, I didn't see that they had appealed that at all. It doesn't matter. There's no error with that one. Let's look then at the post-loss duties. I think we can quickly dispense with this. If we look at the trial transcript from pages 6 and 9 of the trial transcript, day 1 of the trial, Monday morning, the MSJ was on Thursday afternoon. And now here we are Monday morning, and we're talking about what we're going to be telling the jury. And trial counsel for Universal asked the court, before we start, I want some clarification on this motion for summary judgment. The court on page 6 of the trial transcript says, all right, before their side, meaning me, tells me what they think, why they think it's a matter of law or a question of fact, I want to ask you. Counsel for Universal says, I think it's a matter of law. The facts were established through the affidavits that were submitted with the motions for summary judgment. I don't believe there's going to be any dispute about the facts. That's page 6. Page 7, he submitted a proof of loss that didn't have an estimate. And then after the suit was filed, he submitted the estimate. That's the issue. That's the issue. Now, and the question is whether it's a matter of law, or we can talk to the jury about that. And so then I make the point, Judge, at the hearing, this is all on 7. I'm not going to belabor this. You ruled on the record that we had the right to file suit when they denied the claim. And because we did submit a proof of loss, it had been denied before suit. You then found this additional ground that we had cured. We offered to stay, offered to waive our fees and costs if they really wanted that estimate. Counsel gave an trial counsel, or my co-counsel had forgotten to give the estimate with the proof of loss. There's no requirement under the proof of loss that we give that. We did, we offered it, but it's cleared up again on day 1. Let's continue on the transcript. Court said, while no cure was necessary, plaintiffs have cured that defect. And here's what the court said at trial, and here's what Universal's counsel said. I do think that's a matter of law that I've decided. I did decide that meaning you can submit, we could file a suit when they denied the claim. It was cured by the plaintiff, and so therefore I agree the affirmative defense would not be argument, because that's been determined. And what was their affirmative defense? That we had forfeited coverage by filing suit prematurely. That was their affirmative defense. That was not an available remedy for them. I think Judge Kazam and Judge Sleet, you were all, both on Curtis. That's not an available remedy. They could have moved to stay on that issue. And here's where it concluded, and then we started openings after this. And this is me saying this. And so, no, I'm skipping one thing. That's been decided, that one issue about the estimate being attached or not. Counsel for Universal said that's the only issue for the post-loss conditions. And I say this, and so that leaves us with 3 issues. If you look at the pretrial statement, 3 issues to be tried. Whether we prove there was direct physical loss during the policy period. If so, whether the loss is excluded. And if not, what is the amount owed under the policy? And counsel, I think you agree with that. Counsel for Universal says, I agree. They couldn't get forfeiture of coverage at all in this case. That was not an available remedy for them. The only issue they brought up to the trial judge after the summary judgment, it was only 5 days later, was we want to argue to the jury that they forfeited coverage by giving us a proof of loss that, although it had the amount, didn't have an estimate. Court said we could have filed suit when they denied it, but that issue we cured. So unless the court has, well, let me look here. I'll see if there's anything else. To the extent the water damage exclusion, if that is even an issue with Cheatham case, in this case, the perils insured against in Cheatham and the perils insured against in our case are identical, almost word for word, not identical, almost word for word. And the water damage exclusion is almost word for word the same. Those exclusions only apply to sources of water that originate from outside the resident's premises. If there's a loss from the plumbing system, it's covered. We see that in the perils insured against. And I think that's it, unless I stand on my papers on the other issues. Thank you.
Okay, sir. Thank you very much. Counsel, you have 1 minute.
Thank you, Your Honor. So I'll try to be as quick as I can. As far as the trenching to replace the entire system, their expert could not have been clearer that his opinion was that replacement of the entire system was necessary because it was worn out and deteriorated and spot repairs were not available. And again, the policy language could not be clearer that it does not matter if you're able to do spot repairs or not. The only coverage is going to be limited to that. The trial court erred in instructing the jury otherwise and in denying our motion for directed verdict. With regard to the post-loss duties, it was not just the proof of loss issue. The motion for summary judgment was on the proof of loss, which the policy does require submission of an estimate, which they did have and didn't produce. There was also failure to produce documents and failure to provide a recorded statement. All that was in the motion for summary judgment. The idea that a party can materially breach a contract by failing to perform under it, perform their post-loss duties, sue you, then say, okay, we're going to do it now. That cures everything. And you know, that's it, no summary judgment, and they cured it as a matter of law. That cannot be how the law works. If that was the case, no party to a contract would ever have to perform, no insured would ever have to perform post-loss duties. I see you nodding your head, Judge Sleet, so I'm afraid I'm over time, so I don't want to, but I would stand on my papers as far as the collapse exclusion, the water damage exclusion, and the other issues we didn't get a chance to address.
You did well with your time. Thank you both. Well argued. I wish you a good day. To the rest of the litigants and parties, we're going to take a 5-minute comfort break. It's now 11:40 according to my Microsoft time. We'll reconvene and resume at 11:45.